He said that you assaulted him.
But I didn't hit him.
Get out of here. Oh, ow, ow!
So fake.
The judge granted him a restraining order.
I did not hit him.
Did the judge grant him a restraining order?
I'll plead the fifths.
It doesn't matter.
Nadine Unger is suing her former friend, Michael Ponsford, for damaged property and filing a false police report.
Court come to order. All rise.
Have a seat, please.
Judge, case 3166, Unger versus Ponsford.
Thank you.
You're welcome.
Ms. Unger, your cause of action against the defendant has a couple of parts. First, you're suing him for having you falsely arrested.
Correct.
And then you say that he damaged some property which he was storing for you in a unit.
Correct. At his
Okay.
house.
Those are the two things that you're suing him for. He has a counterclaim for property damage, which he's going to tell me about. So first I'm going to deal with your complaint, because I've read your papers, and it appears to me that you two have known each other for a long time. And at some point, after knowing each other for a long time as friends, you began a relationship. In what year was that?
We didn't begin a relationship. I rented a room in his house.
Renting a room in his house, that is some sort of a relationship. That's more than shaking somebody's hand.
It's a relationship. It's a
Well, I
business
understand that, but you
relationship.
were, in fact, in a relationship with him while you were living in his house. Could you give me an answer, yes or no? That's a very easy answer. The answer is yes.
I'll plead the fifths.
What? Miss Unger, please don't play with me. You have a claim, and your first claim is that he had you arrested. And what I am trying to establish is the ground rules for that part of your complaint, having you falsely arrested. You knew each other for a long time.
Yes.
Let's not play with each other. You moved into his house, and when you moved into his house, you began a relationship with him after a period of time.
After a period of
Okay. Very good.
May I present some evidence?
No.
Sorry.
While you were living in his house in the year 2022, 2 years ago, according to you, he had you arrested for domestic violence. And the incident surrounding that, I'm going to encapsulate, and tell me if there is anything inconsistent with what you wrote in your papers and what I'm saying.
Okay.
On this date in 2022, you took his phone. You took his phone to make a call, and you went into another room in the house.
No. He gave me his phone. I asked if I could use it. He gave me the phone, and I went into his shop.
That's exactly what I said.
In the shop. It's not in the house. And I locked the door of his office so I could use
Madam,
the phone.
it's all pretty irrelevant to me, because what I read, what he says happened, what you say happened, two different things, but putting it all together, you took his phone, you went into a room, you locked the door, and according to him, he tried to get into the door, and he wanted his phone because you were looking through his phone, and when he finally got into the door with a key, is that right, sir?
Yes, ma'am.
Because it was his house. He said that you assaulted him. You left the house subsequent to that. According to you, on that day, you went out to a movie and you went for something to eat, and then you went home. That's what it says here. And you went home, and when you got home, the police were there and they arrested you for assault.
I was arrested for assault. I did not hit him.
Just a second. You were arrested for assault.
Yes.
That's what we're talking about. And you were taken to jail. And you were in jail for how many days?
7 days. But I didn't hit him.
Just a second. We're getting to why it doesn't matter, Miss Unger. We're getting to why it doesn't matter.
If I hit him or not?
Yes, we're getting to why it doesn't matter. So you went to jail for 7 days. And when you got out of jail, you contacted the defendant and went back.
No, I couldn't.
And you went.
There was a restraining order.
Back to the house.
No.
Are you telling me that after this alleged assault, you and the defendant, I've read your papers, you and the defendant did not go back to having a relationship for a period of time?
No, never.
After she was released from jail, we made arrangements for Nadine to get her belongings. Is that what happened?
Correct.
Shortly after that, she came to me and apologized and wanted to rekindle things.
No.
She told me how overwhelmed she was, and her outburst was a one-time thing. She never officially moved back in, but she stayed at my house most nights. Are you telling me that that is not true?
That is not true.
Did you ever stay at his house after you got... Careful what you tell me. Did you ever stay at his house after you were released from jail?
No.
Have any proof that she did? That would be anything after September 18th, 2022.
I have the.
No, just a second. Don't speak. Just look.
Well, these.
Don't speak. I'm resting. Just find. Any communication with her after September of 2022?
I didn't say I never communicated to him, but I'd never spent the night there. He won't find anything. There's no evidence I spent the night at his house after that.
I don't know whether you did or not.
I did not.
I had screenshots taken of conversations, but nothing's dated here.
Okay.
There's no
so,
proof because it never happened.
I'm not so sure, Miss Unger, because I don't think that you were actually totally honest with me. In any event, he filed a restraining order against you, a temporary restraining order, according to what you said, and the restraining order was granted. Was it granted after a trial?
A hearing.
Well, a hearing, a trial. You appeared before a judge.
Yes.
And you were sworn to testify.
Yes.
And you testified.
Yes.
Well, you had to testify, and he testified. Other than the two of you, did anybody else testify?
No.
And after the hearing, which has the same quantum level of proof that I have here, the judge granted him a restraining order.
The judge said he didn't.
Just a second. Did the judge grant him a restraining order?
He did.
For how long?
6 months.
Okay. I can't hear, nor will I, overrule that judge's opinion about whether or not he was entitled to a restraining order. And his restraining order was based upon the events that took place in 2022, correct?
Yes.
Just that event. That was the only kerfuffle that the two of you had, I assume.
No.
It's the only time you were arrested.
Correct.
Okay. Well, the judge has already ruled on that, so I'm not considering that. It's not part of your case anymore. It's already been adjudicated.
I have the arrest report.
Have what?
The arrest report where she was arrested.
Does it take her statement as to what happened?
No.
It states
Shh, don't tell me what it states, then I can read it.
Your Honor, I counted 32 lies in that statement to police, the arrest report.
Police report indicates that you had a relationship with him for 2 years.
No.
Not true. Okay.
I moved in July of 2021
And moved out when?
when I was arrested.
I never came back.
Never came back.
Okay. In any event, that case has already been adjudicated. Another judge heard evidence on it, and whether or not there was sufficient showing that he was entitled to a protective order, that court found that he did, and I'm bound by that court.
Those charges were dismissed.
I don't care whether they were dismissed. The dismissal is beyond a reasonable doubt. The quantum of proof, on the other hand, in a civil proceeding is much less. And a judge who heard his request for a protective order granted it to him on the same facts that you're asking me to hear. I cannot do that. It's called res judicata. The issue has already been decided by a court where the quantum of proof is exactly the same as it is before me. I'm not relitigating that case, Ms. Unger. Do you understand? I don't care whether you understand. I don't care whether you understand or not. I've just explained it to you. You want to consult with an attorney? You can do that. The attorney will explain the same thing. You've had your day. I'm not speaking to you.
Okay.
You've had your day in court.
I did not have a day in court. That's why I'm suing him for damages of filing a false police report.
No, madam. You did have your day in court before a judge.
That was before the charges were dropped. The charges,
listen, please.
criminal charges were dropped after the...
It doesn't matter.
After the...
It doesn't matter. This is a civil proceeding. You had a similar civil proceeding before a judge who heard you testify as to whether or not you assaulted him, and he testified as to the nature of the assault, and that court found...
I didn't testify, though.
You just told me that you did. Could you read that back when I asked her if she told her story? Either you testified or you consented to the order. That's the only way. Yeah.
It says, and you were sworn to testify, yes. And you testified, yes.
I did not testify.
So when you told me you testified, you were lying to me.
It was a long time ago. I did not
It was
testify.
a long time ago, too long ago for me, too. There was a final order of protection granted for 6 months. That case is finished. Now let's talk about your property.
I brought a video of the assault when she hit me in the office.
I'd like to see that, by the way, just for giggles.
Me too, for giggles.
Get out of my office. Get out of here. Get out of here.
You get out of here.
Get out of here. Give me my phone and get out of here. God. Oh! Ow! Ow! Ow!
So fake.
Ow! She took my phone. I told her to get out of my shop, out of my office. And now she's slamming the door and twisting my foot.
That is so staged.
Ow!
You're not a good actor.
Okay, turn
I'm
it off.
not even in the picture.
Turn it off. You were in the picture, Ms. Unger. In any event, it really is totally irrelevant. That case has already been adjudicated with the granting of an order of protection to Mr. Ponsford. Now let's get to the property that you say was either taken or destroyed. Tell me what property was either taken or destroyed.
All right, I have pictures. There were 6 vending massage chairs.
It's just 6 vending?
Commercial massage chairs.
And where were they?
They were in my storage unit that we brought to his house on August 29th.
Of what year?
2022.
We're now in 2024.
Yes, I had no resources. I had no money when I got out of jail. I had no money. I had no car. And
what? And you have no case. We're finished. Your property's abandoned. If you left property, it's abandoned. It's done.
I couldn't go back.
This is 2024. You couldn't go back. You had an order of protection that was for how long?
6
months. 6 months. We're 2 years later. And I'm telling you, you have no case.
He says
so
you're a goodbye.
So you're a goodbye. I have a counterclaim. I want to know if it's as ridiculous as her claim. Your counterclaim is from what year?
2022, Your Honor.
2022. Pay careful attention to me. Have you been incarcerated since 2022?
No, ma'am.
Have you been hospitalized for more than a week since 2022?
No, Your Honor.
Where have you been since 2022?
Living and working at my home.
Very good. Then you should have brought your counterclaim, which you could have acted as a claim in 2022, correct? Just answer my question. That's why courts say you have to act within a period of time that's reasonable. 2 years is not reasonable. I say that to her with regard to the property she's fetching about, and I say the same to you. You have a problem with her damaging your property. You should have brought an action 2 years ago.
I dwelled on it for a while.
Well, dwell on my dismissal for a while. This case is over.
This court is adjourned.
Well, I planned on having a case for 2 years, putting it together, and, didn't get a chance.
This case was a great display of timeliness and why it matters, especially in courts. I think 2 years is a long time to wake up every single day and you still have the property damage every single day. And then you don't decide until one morning, maybe I should sue for that. And it takes up court's time. And not to say it's not important, but if it was that important to you, you would have sued in a timely, as you said, to the reasonable person, which in this case is you.
Well, it's unreasonable. You're putting the defendant in a position of having to respond to a cause of action without any specificity. And that's unreasonable.
Yeah.
Okay, good.
Whoa. At the end of the case, what the granddaughter said was, any case you have, you need to bring it to court on time. You don't allow time pass before you eventually decide to bring cases to court, because the more time passes, the more relevance the case lose. And I tend to agree with her, because even when you are angry, if you don't resolve an issue immediately, it takes longer time to be resolved and all of that, and then you find out that you don't even have sufficient energy to have the conversations when needed. So with that being said, the whole case was about 2 people in a relationship that didn't work out. She's suing for damages of property that she left in his storage unit, and he was countersuing for assault and also damages. She said she denied dating him. She only rented in his house, and it was funny when she said she plead the fifth. And in cases like this, you can't plead the fifth, most especially when you are the plaintiff. You are supposed to be the one to have the burden of proof. So you are the one to provide more proof than even the defendant. So for her to plead the fifth didn't make any sense to me, actually. It just shows how ignorant she is of how the court system works. The defendant had her arrested for domestic violence, which he provided video for. I really loved how the video he provided. It proved how violent she was. She hit his phone down and then jammed his legs with the door. And I agree that she should be arrested. She was violent against him, and it didn't make any sense. Then the plaintiff was arrested, and she spent 7 days in jail, but came back. According to the defendant, he said she came back to the house and was trying to rekindle back their relationship, and at the end of the day it didn't work out, so she left. But she actually came back to his house. The plaintiff said she did not return to his house. She denied everything. She said when Judge Judy said, can he provide the communication, she then said she never denied having a communication with him. She only said she never stayed there. So it means that truly, if there's anything, she actually stayed there. It's just that he cannot prove that she stayed there. The defendant filed for a restraining order. Even if it was me, I would file for a restraining order with that kind of behavior we saw in the video footage that he provided. So I agree with what he did. The defendant got a 6-month restraining order against her. The judge that had their case earlier, and that was why Judge Judy said she wasn't going to adjudicate the case, because a judge has already given his ruling and she's bound by that court. So she's not going to hear her case on the false arrest. But she actually deserved to be arrested with that kind of behavior, because she truly hit his phone. She laid her hands on him, and she also hit the door at his leg. So I don't know why she feel bad that he got her arrested and all of that. But then, human beings. The plaintiff said she didn't testify. Yes, that's talking about the restraining order case. She said she didn't testify. But when Judge Judy asked her clerk to back the conversation, there was a place she had already admitted to testifying in the other court before he provided proof and he was given the restraining order. So for her to come back, and I like the way Judge Judy put it to her, that were you lying to me when you said you testified earlier, so that I will know the person I'm dealing with. For her to say she didn't testify, it didn't make any sense. I said it earlier that the defendant provided proof of assault where she hit his phone on the floor. He was asking her to leave his office. She refused, and then she also hit the door to his leg. So it was quite a proof. The plaintiff said she doesn't have money to get her property for 2 years, and that was why she didn't get the property. And that was where that's Judge Judy's granddaughter now trying to explain that if you have a case and the case means something to you, you should try your best and deal with it immediately, instead of allowing it have a longer time and all of that, waste each other's time. The both cases were dismissed because the defendant was also counterclaiming for damages. He said she damaged some of his properties in the house. And I love the questions that Judge Judy asked him. She asked him if he has been hospitalized for more than a week since 2022. He said no. Whether he has been jailed for more than a week, he said no. Has he been to a psychiatric hospital? He said no. And all of that. And it just show how that all those cases, all those things were not important. If it was important to him, he would have come to court way earlier. So I love the ruling. I respect Judge Judy's ruling. It made sense to me. But the defendant was actually acting crazy. I didn't like the way she was behaving in the courtroom. She was trying to plead the fifth for everything, which doesn't make any sense. I believe that you enjoyed this video. Please don't forget to like, share, and subscribe to this channel as we bring you more cases from Judge Judy. Thank you.